Two, one. We are live. I am attorney Vince Davis and my co host, Miss G, Georgette Truan, and this is The Secret How to Fight CPS and Win. Good evening, Miss G. How are you?
I'm good. How are you?
Good, good. So, we're not going to have a guest this evening. We're going to be addressing questions and comments and maybe things in the news. So, what's going on today?
Um, I just I had a very disturbing call like an hour ago, and I just want to just to give a little bit of advice to family, to husbands and wives and parents. I had a call today from a husband that made a mistake. He didn't want to pay child support, so what he did, according to his family, they told him to report the wife to DCFS. He reported the wife to the Department of Child Services that she's neglecting the children. They were involved. They removed the children from her and from him, but he was hoping that the children will be with him. So it backfired on him. So he was in tears. He said, I will do anything. I would never do that again. He just wanted to take back what happened. And he said he can't. And he was in tears. So he was very sorry he did what he did. And I just want to let you guys know that if you both have children, both of you guys decide to have children, don't hurt the other parent because of child support. Don't hurt the other parent because the ones who are going to suffer are the children. The children are the one who's going to suffer because children need both mom and dad. That's it, both mom and dad. It's not about how much money dad has or how much money mom has or doesn't have. I've seen children that 5 children or 7 children grow up in one room, one bedroom that they shared, with curtains dividing the kids. It was That's what kids want, is love and attention, not things. It's love and attention. And being a parent 100%. There is no 50%, it's 100. Both parents, not just one. And that's just an advice I need to give you guys. And I felt the need to say it because it's not the first time that something like this happens. And also, I get women the same way saying that I reported my husband because, you know, I don't like the girlfriend or I'm not happy with the wife or whatever the reason may be. Um, Raise the children, whether you're apart or together, raise them. And don't worry about who they're with. Worry about yourself and your children. And that's it. That's all I have to say.
Okay, so tonight we're not having a guest. We're going to be answering your questions. So post your questions in the comment sections. We should get a lot of questions this evening. We're streaming live to 8 different social media sites on Facebook and YouTube. So let's get those questions and comments rolling. All right, Miss G, while we're waiting, any questions you want to ask me that people may have asked you today and you didn't know the answer to or you wanted to ask me about?
Um, there was a couple of questions that came to me today about judges. Several people want to change their judges. They want to know if it's the same with DCFS courts. Can they change judges in the Department of Child Services courts
Oh, yeah.
in
You know,
California?
the first time in California, at least,
Hmm.
and I'm assuming that it may be similar in other states, but you need to check with your lawyer.
Hmm.
In California, after your first hearing,
Hmm.
which is the detention hearing, you can change judges by filing an affidavit pursuant to California Code of Civil Procedure 170.6. Now,
Hmm.
you could file that 170.6 affidavit before the detention hearing,
Hmm.
or you can file it up to 10 days later. And that's California case law. Now, after that, if you don't change judges, there is a 90% chance that you're probably going to be stuck with the judge for the rest of the case. There are several ways, though, even after that, that you can change the judge.
Mhm.
And, you know, there in California, it's set out in case law and in the Code of Civil Procedure. The first way to do it is to file a motion for actual prejudice. And I've seen that filed many times. And, you know, it doesn't always work, but it puts the judge on their toes because, you know, you're making allegations that this judge is somehow prejudiced against you. And
Mhm.
not a good thing to have on your record if you're a judge, right? So, but you got to have the facts and the law behind you. And here's one thing that is not prejudice: a judge making a decision that you don't like, right? So here is actual prejudice. The judge says from the bench, "I don't like people that wear glasses." Okay, actual prejudice, right? Or if the judge makes some type of comment. I've actually, this has been a few years ago. Um, it was, I wasn't there, but someone told me about a judge making a comment about American Indians, you know, and apparently, you know, it wasn't politically correct. And apparently, that judge not only, I think, was removed from the case, but ended up shortly after that, I think, leaving, you know, the bench. So you can make those types of motions. I know an attorney. As a matter of fact, I'm on a case with an attorney who recently filed a motion to disqualify a judge and to get a new judge based upon comments the judge made to the attorney about the attorney not being able to be there on a certain date.
Mhm.
Um, Apparently, the judge accused him of something, some wrongdoing. He had evidence that showed that he was, you know, had the backup evidence to show that he wasn't able to be in court on that date and time. And yet the judge had made these comments about him. And he filed a motion against the judge to have the judge taken off the case for actual prejudice. So, you know, the issues of actual prejudice could be infinite. They could come up in different ways. You know, you might discover that, you know, the judge on your case is somehow knows one of the parties, somehow related to one of the parties.
Mm.
I'll give you an example. My ex wife is a judge in CPS court. She, to maintain um, integrity, will not do any case from my law firm, and I think that's a, you know, that's a good move. Um, and she used to work for my law firm even before and after we got divorced. So that's, a lot of judges take those precautionary steps. So you can file that. Another way you can get, but there's a trick on that I want to mention to you. When you file those types of motions to get rid of a judge, one of the things you got to watch out for, in California at least, it's supposed to be sent to another county, and the judge is supposed to make the decision in another county. A lot of times, they try to get the motion decided or get you to agree to have the motion decided somewhere in the building or the same courthouse or someone in the county. Now, that's
Mm.
not what the statute said. The statute says is it's supposed to be a judge outside the county. So that's one of the things you want to watch out for. Um, the other way you can get a judge off the case is if you file an appellate writ or an appeal and you win, you get the right you get the right to have a new judge.
Mhm.
And that's probably um, one of the most, I guess, quote unquote, popular ways, other than, you know, calling a judge, you know, straight out prejudice. You know, judges are smart people. They may be thinking something which you can't prove, but you know, very rarely do they do something or they say something that can be used against them. Sometimes, you know, judges are people, and they, you know, in the heat of the conversation, they might say something that
Mm.
you know, make that mistake and let it slip, and then, you know, that gives an attorney the opportunity to make a motion against that judge.
Judges are people. That's interesting. Um, Interesting. Okay, so I wanna I would like to start with Cassandra. Miss Cassandra. She wrote a message. Hi, Mr. Davis and Miss G. Hi, Cassandra. We miss you.
Was that the question?
No,
Oh,
I had to address my Cassandra. Let me just say hi
okay.
to my girl. And my other girl, Lisa, LJ, our other co-host. She said hello. Thank you, Lisa. Gorgeous Miss G. And hi, Mr. Vincent.
I don't see a comment from Lisa.
Right there, rise up. That's Lisa. That's LJ.
Oh, rise up. Okay.
Hmm.
Hello, gorgeous Miss G, and hi, Vincent. Hi, Lisa. How are you?
Okay, so the
Here's
comment.
yeah.
Wait,
Here's a question.
this is from what I said earlier about, you know, what I said earlier about child support and reporting the other person to DCFS. They wrote, "What do you do if the other parent doesn't cooperate with the beautiful reality? How can parents fix the broken attributes of it being about the children and keeping that focus of understanding?" Can you answer that, Mr. Davis?
No, because it's a very difficult question, and it's different from case to case, different from person to person, and it assumes something. It assumes that everyone in the case, both sides, are acting fairly and reasonably, and that's
Um,
not always true. Not
it's
always
look,
true.
what I have noticed in family court, they their focus is to give 50-50. It doesn't matter if one parent is a narcissist, and it doesn't really matter to them. They When you're dealing with a difficult parent, you can't co-parent with that parent. It's very hard to co-parent. So they have Family Wizard, for example, to communicate through via email, which the emails are transferred to the court. So the court have access to Family Wizard. And there's another service that the courts use that's for it's free, but Family Wizard is for like $100 a year, but the other service is for free. So your attorney can request that from the judge to communicate via email. So that way there's peaceful communication. And if the other party is being an ass, right, or vindictive or mm, accusative at all times and not making it the focus of the children, then you can go back to court and address that with your judge. I mean, with the judge as well. So you might want to have an attorney. If you want to do it on your own, I suggest you get an attorney's opinion and how to handle yourself in court, because oftentimes words are very powerful. You don't know the language of the court. You just don't know it. And sometimes what you say can be held against you, so you have to know how to address the issue in court. Am I correct, Mr. Davis? Or
Yeah, I would agree with you.
okay, that's very wow. Okay, thank you.
Okay, and then Goddess says, "What about acts of prejudice that actually exist as well?" Well, in California, probably in most states, you can make a motion uh, to have a new judge if there's actual prejudice, and most of the time that should be those motions have to be judged or decided by other judges. In California, the statute actually says judges in other counties. Okay. Here's Mania says, "Is it uncommon for CPS to get medical records changed that will make the parent look mentally ill? Is it
Yes,
uncommon?"
I mean it is. Wait, what?
That's a double negative there, Miss G.
I know. I'm sorry. It just hit me. I'm like, wait, what? Um. Hmm.
Is it uncommon? Well, the way the question is written, I would say, Mania, that it is uncommon um, for CPS to get medical records changed. Now, what I'm envisioning the question meaning is that they physically go in and change the records. That's pretty hard to do if you're not a hospital employee. But if you mean that they talk to the psychiatrist or the psychologist and prejudice the psychologist against you, That probably is more common.
Very common. 100% common.
So, if that's what you're talking about, I would say that would be more common.
Hmm.
Social workers tend to talk to witnesses and somehow convince them of, their position. And sometimes that includes you being mentally ill. You know what? I've been seeing a lot of cases lately. I was going to say lately, but it's not true. I've seen this all throughout my career. Um, Social workers kind of convincing someone that you have a mental illness.
Hmm.
And the sad part of it is most, if not all, social workers not qualified to have that um, to make that decision.
Hmm.
Several years ago, there was a big lawsuit, civil rights lawsuit by a woman who the social workers had alleged that she suffered from a mental health disease, something called Munchausen syndrome by proxy. When she finally sued the social workers, I think the jury decided that the social worker wasn't qualified to make that allegation without trying to prove it with some mental health professional. Now, Miss G, if we were in a court of law and I was a social worker and you were a mother, and I said, "Oh, Miss G is crazy," I can say that all I want, but in order for that to hold water, I got to get some type of psychological or psychiatric evidence, from someone licensed to say, "Yeah, I talked to Miss G. She's wacky." Otherwise, it's just me talking, and I ain't no psychologist and I ain't no psychiatrist.
But
I've had
you say that to Miss G every day, Mr. Davis.
I actually had a case where I represented a guy, and that's what the social workers were saying about him, and he actually ended up testifying, and the judge at the end of the case made a decision that he disagreed with the social workers. And it was interesting. I forgot the exact words the judge used, but he said something to the effect that, he's a peculiar guy, you know, he's an odd guy, but I don't have any evidence that he's psychologically or emotionally not balanced and can't take care of this kid. So,
Social workers and caseworkers, what are the difference between the two?
in my mind, nothing. It's
Okay,
just
so
it's like attorney lawyer
okay,
in this state and in this country, no difference.
okay,
Now, in some other countries, there might be a difference. I think in England or the UK, it's barrister and I forget solicitor, right? And apparently, there is a difference between those two. But
okay.
in LA, excuse me, in this country, California, attorney lawyers, it's the same thing. And in my mind, the way I use it, caseworker, social worker, same thing. Okay, here's a question from Rise Up. Question from a viewer wishing to remain anonymous. I guess you shouldn't mention her name, Miss G. If a parent lost their housing due to a domestic violence situation, how how does the now homeless parent get their child back? Oh, that's such a good question. Because I've actually had that issue come up. Um, and let me tell you the story of the case I was on. This is many years ago. I represented a woman who was using cocaine, admittedly using cocaine, and they took her 5 children away from her. And then it was continued to the 6 month date. Well, to everyone's surprise, this lady did drug counseling, drug testing, individual counseling, parenting, to everyone's surprise, and got clean and sober. And the social worker wrote a report at the 6 month review date that said, "Oh, I'd give so and so her kids back, but she doesn't have a place to live now." At this point, the woman is couch surfing from friend to family to friend. And what happened was she had housing through the housing authority here in Los Angeles. And because she didn't have her kids for that 6 month period, she lost her housing. and it was, I believe it was Section 8 housing. So in order to get it again, she had to get in line again, through housing. But that had nothing to do with the court and CPS or DCFS. So I made a motion. By the way, as an aside, and this turned out to be the most important factor, the department or CPS was paying $5,000 or $6,000 a month to the foster parents who were taking care of these kids. And I made an argument, and the judge told me to put it in a motion that they should give housing to the mother as part of her family reunification services in order to get her children back. And by the way, I said, and judge, it would be cheaper for the county. You know, they're paying $5,000 or $6,000 in foster care payments. Why don't they just give her, $1,500 or 1,000 or $2,000 so she can get a place and she and the kids can move into it?
Wait,
I was telling a story, Miss G.
but I want to make a comment on what you just said about that, what you told the judge. But what I found out is that the reason the county does that is because they're not going to get their funding unless the children are placed in a foster home.
Okay. So the judge kind of agreed with me, but I had no like legitimate legal proof to do that. So what I did was I wrote the motion and I focused on how reunification services are defined in the Welfare and Institutions Code in the section 16,500, etc. Sections that are very rarely mentioned in the juvenile court. And it defines family reunification services. And although it doesn't say provide housing, it uses language that's very broad, you're supposed to provide things so the child could get returned home. And then I found a case, and I think it was in Arizona, an Arizona Supreme Court case. I don't know if it's in Arizona or New Mexico, but it was in the Southwest someplace where the Supreme Court of that state actually said, "Oh, you got to help this lady get housing." That's part of what family reunification services are.
Mhm.
It's the most basic thing. I ended up making the motion. The county didn't want the judge to rule on it because it was going to set some type of precedent, right?
Mhm.
CPS has to pay for the housing now, and they didn't want to do that. Not that they really couldn't afford it, but they had money earmarked for other things. New furniture at their attorney's offices, you know, m- raises and benefits for the social workers. So after two or three hearings, and each time the case was continued, the number two man in CPS in LA County came to the court, and we all met together in the judge's chambers and said, "Look, if you take your motion off calendar," because the judge hadn't made a decision, "if you take your motion off calendar, we're going to provide her with housing." And, with my client's permission, I took the matter off calendar and they provided her an apartment. Not only that, but they got donations for furniture, appliances, refrigerator, stove, the whole works. I mean, she was set for at least about a year. And then they wanted to close the case because they're paying all this lady's, house rent and, to helping her really take care of the kids. So that's rise up. That's one of the ways that you can do it. So if you're in California, look in the Welfare and Institutions Code section 16,500, and they actually define what reunification services are. Now, they don't mention drug counseling, drug testing, stuff like that, and they don't mention housing. But in a lot of these cases, one of the only things the social worker says is, "Oh, she's homeless. Can't give her back her kids." Right?
Mhm.
And that's when you should use that argument. So rise up, that's what I would do in making it. Now, a lot of people, I bring that up over the years and these days, and a lot of people, they scoff at me like, We don't have to pay for their housing. How could you possibly think that?" And I just chuckle to myself because, 20 years ago or more, probably, I actually did the legal research and wrote a motion on it. So rise up. I hope that answers your question. Talk to your attorney about it. In my opinion, family unification services means helping you get housing. And by the way, in when I made that motion, the county argued that gifts of government funds to people was unconstitutional, and straight out gifts are. But I said this wasn't a gift. This was actually a reunification services because the social worker had written the report, and he said the only reason why I'm not giving her back these children or recommending it is because she doesn't have housing. Well, if she doesn't have housing and that's the only reason, well, you haven't provided family reunification services because she still can get that rent. Now, I don't think they do this anymore, but one of the things they started doing many years ago when you had a housing issue was hooking you up with the, for example, LA City Housing Authority and helping you get housing, helping you get Section 8 so that you could get your kids back. Now, I haven't heard that being done in a decade or two probably, but that's one of the reunification services that they used to give you. So also ask your social worker or your attorney. Ask your attorney about that. Miss G, did you want to say something?
Um, no.
Okay. Okay, here's Chris. Cassandra, I think you asked that question. Cassandra, in my experience in California, there's no difference.
The
Now,
social worker's licensed to basically deliver services.
no,
So she's licensed,
no,
he or she licensed to deliver services, right? Where the
no.
case
Social
where
workers are not licensed at all.
to deliver services. The
They are not
difference.
licensed at all.
Okay, good to know. I'm just
Yeah, they
making.
have no license.
Okay.
Now, some social workers have licenses as therapists, but that's a rare thing. And not too long ago, maybe a couple of years ago, I was actually on a case where the social worker was a licensed psychologist,
How sad.
right? So it was tough challenging her because she could say, well, I'm qualified. I think your client's, an idiot.
Hmm.
Right? Your client didn't get anything out of it because when I talked to him, I professionally assessed, because I'm a licensed psychologist, that he didn't get anything out of the services and therefore should not get his kids back.
Mm.
The case became kind of ridiculous. And even the judge, started shaking his head, I think, listening to everything the social worker was trying to say, because my client, to meet him is to know he's just an ordinary guy. There's nothing wrong with him. And he did get his kids back.
A
Um,
license doesn't. A license doesn't. I never mind. I want to say something really bad right now, but I chose not to. So just
oh, okay. So here we go. Laugh out loud. Love how they must prove things before making decisions. All right, looking for some more questions.
there's a question I would like you to address. Tracy, great channel. Chanel, something like that. I can't see it very well.
That question, my daughter was taken from her father, and I am the non-offending parent. But CPS won't give me my daughter. What should I do?
Yeah, when they're not the, for example, if two parents separately live separately and one parent got in, well, I don't know, with DCFS issues, why does the other parent have to pay for what that parent did or the parent's girlfriend did?
I don't think they should. As a matter of fact,
But
Tracy,
it
I hope.
happens, Davis. You know that. I mean,
Well, that's because I'm not on the case. I'm not on every case in the world, Miss G. But I'm going to tell Tracy what she would do. How about that?
Mhm.
Okay. Tracy, assuming you're in California, and I would have to assume it's, similar in other states because federal regulations mandate what laws the states put out there regarding CPS cases. In California, you and your attorney should set this matter for what's called a contested hearing immediately. Because even if CPS doesn't want to give you the child, the judge can give you the child over CPS objection. Remember, I say this. I say this every show. If the social worker doesn't want to do something, and you don't challenge it with the judge, or challenge it with the judge and you lose and you appeal it, which a lot of people do, you're going to be stuck with the social worker's decision.
Hmm. I
So
love it. I love it how you say that over and over again.
So take it to the court, make sure that you have the right procedures, make sure you have filed the right motions if necessary, make sure that you file or that you have the right evidence. Your witnesses lined up, your documentary evidence, you
Mm.
know? So make sure that you have that, Tracy, when you go to court. Oh, Tracy says she's in Oregon. Tracy, I actually did a case in Oregon a couple years ago. So in my mind, Oregon is very similar to California. You just need to get a lawyer that is going to help you. I was on a case. I forgot what county that was, but in the comments, Tracy, tell me what county you're in. Let's see, Cassandra, Miss G. I tell you after the show. LOL. Okay, must be an inside joke. Okay, Goddess says domestic violence fund, general statutes, no legal advice, and Miss G is right about the funding comment.
Thank you. Thank you, Goddess. Thank you.
Let's see, Monia says the same caseworker got assigned to my daughter, and again defending the father, stating the bruises are unfounded. Monia, I see that happen a lot. Sometimes a social worker gets on one parent's side, and it becomes personal.
Mm-hmm.
You know, um, so I see that happen a lot, but that's what happens with people. They sometimes develop a prejudice, and when that happens, you got to fight harder. You got to
Mm-hmm.
get your evidence together. You have to challenge the social worker in trial. Put the social worker up on the stand. Cross-examine the social worker. I have a video on my YouTube channel, how to cross-examine the social worker. Take a look at that. You and your attorney talk about that. Ms. G, you were raising your hand.
Yeah. I oftentimes I see that social workers side with, for example, if two parents are married and they're reported by the hospital, whatever, because they took their child to the hospital, um, they try to separate both parents, right? When two parents are separated and one hates the other, right? The social worker always sides with the male parent, even if they abuse the children. And I was told by an attorney one time that it's a man's world in the court system. So, what's your thought about that?
It's a man's world in the CPS system.
Hmm.
I would disagree because
Mm.
most social workers are females, and I involved in well, just my personal
What does that have to do with it, though?
my personal observation after thousands of cases over 36 years
Mm,
is that social workers
mm.
have a tendency to lead towards the mother.
No, I don't think so. No,
How
not at
many
all.
cases? How many cases you done?
Look, I don't care how many. You could have done 100,000 cases, but what the point I'm trying to make, that is not true. Social workers do not side with mothers. I'm sorry, they don't. They
There's some
really
very there's some very famous cases. I'll have you look up um,
don't.
federal cases, as a matter of fact, appeal
What year
cases.
was this? What, 1900 or what?
No,
What year was
like in
this?
the past 10 years.
Okay, that was 10 years ago.
No, I said within
That
the
was
past 10 years. Within from 10 to 1 year ago.
hmm, hmm,
And it
interesting.
just depends on the social workers because sometimes social workers are men. Sometimes social workers are women. You know, I think I think you believe that they're trained to do that instead of personal preferences that they have themselves.
You
You
and
know,
I both know they're harder on women than men. And
I disagree with that.
they actually side with the abuser. Don't, you can disagree. I don't, that doesn't mean anything to me if you disagree or not.
Right.
They side with the abusers. Do not tell me they don't. They do. All right? So that's your opinion, that's my opinion.
Itty Bitty says, can you repeat that code. I think that you were talking about Welfare and Institutions Code, section 16,500, etc. It deals with defining and telling us all about what family reunification services are or is. The interesting thing is, I said that you rarely hear, maybe I've heard of these statutes quoted inside the CPS court on a very few occasions. We talk about family reunification services, we talk about family maintenance services as if we know what that means. And the truth of the matter is, most people, even the lawyers, don't know exactly how that's defined within our laws in California because we just don't address it. Maybe there should be more cases challenging family unification services or the sufficiency of family unification services and what they're supposed to be offering to these parents. Rise Up says states have funding and grants for reunification services, but CPS tells people they do not have the funds. Rise Up, that you're absolutely right on that. You're absolutely right on that. Um, let's see. There was an attorney, and he posted it on Facebook. I don't think Instagram, but he posted it on Facebook. Several years ago, he did a deposition of a social worker who was the chief financial officer of Orange County Social Services, or CPS. And he had her explain the entire how things are laid out financially and where the incentives are, and how they correspond to what's done in the case. And it's a fascinating deposition about how they think and how everything is related to money. A lot of times we go to court and, we assume that social workers are doing the right thing, or the judge assumes it. And that's not entirely correct. They are influenced heavily by money decisions, money from the federal government. Tracy's great channel says, but once I refused a drug test because this wasn't about me. Okay, Tracy, I'm not sure what you mean by that. Let's see. We're going on to some more comments. The caseworker is a male. Here we go. Um, the caseworker is a male siding with the father. What do you think of
No,
that, Ms. G?
I disagree. In order for you to break a family, you have to break the mother. The mother is the closest link to the child. The mother is the closest link to a child. So, in order for you to break a family, you have to break the mother. In order for you to break the mother, you steal the most important thing to her is her child. This is a tactic of a narcissist, sociopath, and social workers and the government. They attack the woman first. Always the woman first. Even if the father and the mother are married and they're happily married, and it was a report from the hospital because the father is concerned about the child's fever, or the mother, they try to separate them from each other. They go to the father and say that the wife said, then they go to the wife and say the father said, then they get them to fight, then they get them to go, domestic violence, then they separate them. This is not family reunification shit. This is about the government making money out of separation tactics. That's what it is. So I don't care what anybody says. I don't care what anybody thinks. That is my opinion. I'm sticking with it. And I have the right to speak my mind. Period. That's all I have to say. You're muted, Davis.
If you're ever thinking about suing the social worker, check out this website, cps.info. Get some information about that. Okay, looks like we have run out of questions from our audience. Miss G, anything else you want to say or ask this evening?
Yes, I want to ask, when it comes to one parent violating a court order, CPS court order, and the social worker in California, that is in LA County, and the social worker decides that it's okay for that one parent, the male father of the child, to violate the court order. It's okay. but then goes to court and tells the judge that it was the mother that violated the court order. What's your feedback on that? When the mother has proved that it was the father who violated the court order.
When you say what's my feedback, what do you mean?
What advice would you give them?
Get a good lawyer. I mean, what else can you do? I mean, you need to present your case in a legally sufficient manner with the right evidence. You know,
Mhm.
things, I'm in the middle of taking a review course. It's online on evidence from a very famous law professor and trial attorney many years ago. His name is Irving Younger, or was Irving Younger. You might want to Google that. And one of the things that he said, he takes you back to the basics. What you just said to me was reality.
Hmm.
It's real. And it's true. The problem is that it's not reality inside the courtroom. Reality inside the courtroom is what you can prove. If you got a good lawyer, you can prove it.
Wait.
If you don't have a good lawyer, it's going to be hard for you to prove it because judges aren't supposed to make decisions
Mm,
based upon reality. They're supposed to make decisions based upon the evidence, the admissible evidence.
correct.
Mhm.
So when the judge looks at the evidence, still sides with the social worker. What
But
kind of
see,
judge is that?
here's the problem. Because you are assuming that the judge is going to agree with you on the credibility of your witnesses. See, this is where I say it's a false reality. The judge can decide, you know what, Miss G, I don't believe your witnesses, and then rule for the father.
Interesting. When there is cameras involved,
Okay. Do you know how to get video evidence into court?
the attorney should know, and the
Well,
attorney did. The
well,
attorney did. The attorney did. Davis, I understand what you're saying.
I don't think you do.
It's not about. Yes, I do. I actually do. I actually do. I actually do. What happens in court? Okay, when the attorney submits the evidence, right? A camera outside the door that shows the father violated a court order. The attorney submits evidence, right, as exhibits. The judge looks at it, says, no, I
Yeah.
still believe the social worker.
Well, here's the thing. You're taking a couple logical leaps. And that is, for number one, is you believe that the attorney did it the right way. Okay. First of all, any video evidence can be tampered with. Do you believe that?
I don't believe that, no.
You don't believe people can manipulate video and pictures? I mean, have you ever heard of Photoshop?
No, because
You've
when you
never heard
have
of you never heard of Photoshop?
we're not talking about Photoshop. We're talking actual video. Video that is downloaded to your phone. Phone.
Miss G, video can be changed anytime in
You
any
can't
way.
change a ring
With
video.
w-
You
yes, you
can't.
can.
No, you
Oh,
can't.
yes, you can.
You want to bid on that?
Yes.
Okay, I'll bid on that. $100.
I wouldn't shake your hand for $100. Add a couple more
You know
zeros.
what? No, forget you. Forget you. I'll bet you $100 and that's that.
Now, how
You
about
can't
this? How about
manipulate a
this?
video.
How about this?
Pictures you can, but not a video.
Okay. All right.
Don't even
You
go
know,
there.
you know, you know.
You wouldn't
I
shake my
want you
hand
to.
for a
I
hundred
want.
dollars. All
I
right,
want you to ask our um, private investigator. What's his name? Art. Ask
Art.
Art Bustamante.
Mm-hmm.
Okay. Ask Art, can video be altered?
Regular videos from your phone, but
Ask him.
not from the
Ask.
Ring cameras.
Okay. Ask him.
I will.
Ask.
You
Okay. Ask him.
can't freaking put a person there breaking your door on a fucking camera.
And then after he
See, this
says
is
that,
why I cuss. It's because of you and the social workers. Look at me.
after Art
I bet you
says
$100.
after Art says that I'm right, I want you to send me the $100, and I want you to make up a sign that says Mr. Davis was right and put it in the back of your background there for a week of shows. Okay?
You know what? That will never happen. I will never have a banner that says Mr. Davis was right for a whole week. Never. Ever. Not in this lifetime.
Oh, oh, look, Rise Up. Rise Up says, what is
Shut
Rise
up.
Up?
Shut up, rise up. Just shut
He's
up.
right. You know what? The good thing is we get to save these videos for life, and we can replay Miss G's comments.
Whatever.
Um, all right. You know, Miss G, we've come to the end of the show tonight. We're kind of on time. We're a minute
Put it
over.
on his calendar.
Oh, we got Miss Payne. Miss Payne, you're on the wrong side of this one.
I love you, Deidre. She just always knows what to say. She's so right on it.
Okay,
Oh my god.
Rise Up. It still can be edited.
It's
You
not. It's
are
not.
absolutely right,
Not.
Rise Up.
Not.
You're
It's not.
absolutely right.
I'm gonna get you guys the answer tomorrow, God willing. I will get you guys the answer tomorrow, and I'm not gonna forget. I guarantee you. But I do have one more question.
Everyone, join us tomorrow at 7 to watch Miss G eat humble pie
I'm
and
not gonna eat humble
apologize to
pie.
me. Okay, what's your last question?
It's not a last question. I have three more questions. Okay, three.
Jeez, we're really going over tonight. Okay, go ahead.
Well, how was that? It's 7:49. What clock do you have?
What clock?
Yeah, what time do you have? It's only 7:49.
The show is 7 to 7:45.
Oh.
Right.
Anyways,
I just say that every show that we do, but go ahead.
my question is, when the court appointed a stop it, Davis, take that.
Cassandra. Okay, go ahead.
Cassandra,
We'll,
we'll
we'll
talk
just we'll
afterward.
just
I mean,
we'll
after
just
this show
leave
is
that up there for a minute. Go
done. Okay.
ahead, Miss G.
All right. When the court appointed attorney forces the parent or try to force the parent that you don't want to go to trial, so just plead, just say
No contest.
no contest.
Mhm.
What's your, is that good to do, or is it against the parent to do when not going to trial?
Okay.
Does it depend on the case?
It
Case to
does
case.
depend on the case, but let me tell you this. Generally, this is just general. I don't think a parent should do that, especially if the parent believes and feels in their heart that such and such incident didn't happen. I was talking to a lady today that said that she tested positive for drugs and that she swears up and down she doesn't do drugs.
Mhm.
And I said to her, have you ever heard of a false positive? She said, no. What's that? I said, well, drug tests are not 100% accurate. And here's the interesting thing. After she tested positive, they took the child away. 3 months goes by. She tests twice a week for them. She has a hair follicle test. All are clean. That would lend credence to the argument that it was a false positive, but it also, she could have asked for a retest, which I don't think she and her attorney did. But here's the other thing. Assuming that it was positive, 3 months of clean tests twice a week, that would mean you do not have a drug problem such that the child should be taken away from you. and there are less restrictive alternatives. Here's an alternative that used to be used all the time, and I rarely hear people mention it. Okay, judge, we take the kid back and we'll test twice a week randomly. And as long as we test clean, we're cool. If I test dirty, okay, you can place the child out of my care. Well,
What if they do?
what's wrong with that? They just take the kid away from you,
Right.
and they don't talk about the less restrictive alternatives.
Do you?
Several months ago, I was doing a trial on the less restrictive alternative issue, and you know what? The county council objected as being irrelevant,
Hmm,
and I was thinking to myself, are they looking at the same law I'm looking at?
no, they're not. What if the
If they are trying to sweep it under the rug, and if they're not really familiar with the law.
They are familiar with the law. I just finished telling you that the only reason they do what they do because they're not going to get the funding if the kids are not placed in foster home. Period. It's not the same funding that they get. So it's they get more money when the kids are provided services and the kids are placed in a foster home.
I
That's
agree.
okay.
Tr
So let's just make
Tracy,
that very clear.
If you need to talk to a lawyer,
Just email
bot
me.
bottom right-hand corner, 888-658-82. Now, Miss G, you said you had 3 questions. You gave me 1. What's the other 2?
If they're accusing the parent of doing drugs and the parent swears up and down that they don't do drugs,
Hmm.
why not provide the parent, I mean, have the parent do a hair follicle test? I remember that happened with one of our attorneys. There was a case like that, and the attorney had the parent do a hair follicle test. That hair follicle test, I guess, goes back to 6 months, I believe.
Well,
Something like that.
there's different lengths of time depending on
Hmm.
the length of the hair and the test that they give. Yeah, but it
Right.
can go back like 5 or 6 months. I've
Okay. So
even seen articles that say it could go back 9 months.
right. It can go back 9 months. So she had her do the max, right? So the social worker had her go to their drug facility. All of a sudden, the hair follicle test shows that she did no drugs for 9 months. Nothing, nothing. So how can their facility says that this woman does drugs? See, that's what blows my mind. But you tell me that they can't alter a drug test.
No, I
Yes,
didn't say
they
that.
can.
I didn't say that.
Well, somebody did. Maybe another attorney did in our office. But they can alter drug testing because the
No,
attorney
but
in our office,
here's what you're not understanding, Miss G. It is a possibility that I could take a urine test today and test positive for meth because it's a false positive. If there's a 3 to 5% chance every time I piss in a cup. If I do it 100 times, 3 to 5 times, it's going to show positive, even though I didn't never use meth. That's just the scientific weakness of the test itself. They're not 100% accurate. That's why federal law says you can ask for a retest, and if they don't give it to you, they can't use it against you.
but
A lot
they
of
do. They
I
do
know
use it against them.
because a lot of people don't know how to request the retest. Okay,
Okay.
a lot of people don't even know you can demand a retest.
Right. So,
In LA County's contract with the drug testing company, there's a long section in there explaining how retests will be done. But nobody tells you that. Tells you that you can force a retest. The other thing is, since it's 3 to
the
5%
social workers tells them that, Davis.
plus 3 to 5% false positive, if you take a hair test, okay, that hair test could be a false negative. Because even though the margin of error may be 1 to 2%, that hair follicle test could be false negative. So there's never 100% accuracy. Never. The only person that really knows is the person who's being tested, and sometimes they don't know because sometimes they have contact in their environment and they pick up something and they're going to test, positive for something, and they don't even know it.
Hmm.
Here's something that Tracy says. In California, they are unconstitutional. But here's the trick: if the judge orders hair follicle and you and your attorney don't object to it, guess what? You have to do it. You have to object to the hair follicle test being unconstitutional.
Okay, read what Rise Up wrote, please.
Hair follicle can hold drug residue, which can be vary based on different hair types. Okay, Department of Transportation does not use that testing. Why should parents? It's unconstitutional. I don't think you should be using it at all. One of the other tests that's unconstitutional is blood. But you know what happens? And I argued this once, and the judge ruled in my favor, but on different grounds. I didn't think they really wanted to address this. You know how when you have a baby, and sometimes they do a test on what's called your marconium,
Hmm.
deep cord inside you. That's really a blood test.
Hmm.
That's unconstitutional for them to use.
Wait,
But
after you
what
have
people
the baby or before you have the baby? Or
after after
oh,
it's an unconstitutional blood test.
I never knew that.
Yeah, comes up. There are many cases where they'll take the kid away because the mom tested negative, but the kid tested negative. But in the mom's marconium, there was traces of meth.
How is
Or
that possible, though?
right, exactly. Because they say that the marconium is more of an accurate test scientifically, and it goes back further. But the whole process, unless you agree to it, it's unconstitutional. And I don't think the courts and people are arguing that right now.
Hmm. Toby Henderson wrote something. Would you please read that?
Okay, ask me your next question. I'm not going
Oh,
to stay on for all night long.
okay. Well, read Toby first, and I'll ask you the next question.
No, ask your question or I'm signing off.
Oh my God! See, this is how he acts with me at work. Now it's all over nationwide. Okay. Anyways, my next question is: if the parent are being pressured to admit guilt and they record their court appointed attorney, can that be used and sue that court appointed attorney? Can they use that against the court appointed attorney for pressuring them, for lying to them? Like, say you're guilty, so you're going to get your kids back. For example, say you're guilty, you're going to get your child back. And but they're not guilty. They didn't do anything. The child was sick, went to the hospital, and they said they're guilty. Why? Child had a fever. So,
They could use that to sue the attorney. However,
mhm.
when it comes time for a motion to dismiss or a motion of summary judgment in the case against the parents in the civil case, the parents might lose because when you go into court, you swear under penalty of perjury that you're telling the truth.
Mhm.
So if you say under penalty of perjury, I'm guilty,
Mhm.
how are you going to erase that in another case? That's the danger. You can't say, okay, I was under penalty of perjury and I admitted I used drugs, and then come back and say, oh, the attorney forced me to do that. Well, wait a minute. You were sitting in court and the judge asks you, did anybody force you or, and you say no. You say all of these questions under penalty of perjury. So how can you later come back and say in another case, well, he forced me to do it? That's the catch 22.
Yeah, I understand that, but what I'm saying is when they refuse to admit to the guilt that they didn't do, and
Mhm.
then they recorded the attorney pressuring them, can after this whole thing, can they sue that attorney for trying to force them to admit guilt? The attorney's telling them You know what? It doesn't matter if you think you're guilty or not guilty. It doesn't matter. You just have to say you're guilty to get the children. You have to sign here, say you admit to the guilt so you can get the children.
Well,
That's it.
so the answer to your question is
Mhm.
they can use it, but that doesn't mean they're going to win,
That's messed up.
right?
So basically, we humans have no right in the America.
Oh, you do. You just have to know what you're doing. And most ordinary people don't know the legal ins and outs.
So do you believe, or is it true that when the child is born, they are automatically awarded to the state once they have a birth certificate and a case? I mean, a social security number. I mean that they belong to the state.
No, not at all.
Why is that?
They belong to the parents. It's a
No,
recognized constitutional right.
no, is that's not true. You know why? Because the state takes them from the parent, so they do belong to the state.
I need to send you some cases, some very famous cases that discuss that dilemma and that issue. And if you after you read the cases, 2 or 3 times and it finally, sinks in because I had to read them 2 or 3 times myself, you'll realize that it's a very fine line, but the children belong to the parents. And as a
Mhm.
matter of fact, the Supreme Court of the United States says CPS can't take the children unless certain conditions are met.
And that's not followed though. So
Well,
CPS still
no,
stands,
it
even though
follows.
they're in violation,
They
right?
follow
Of law.
it sometimes with evidence that you disagree with.
No, with evidence. No, it's not even evidence. Why would you say evidence? They make up their own allegations. They literally fabricate information to get what they want. But anyways, I'm not in fond of CPS. I'm not fond of the judges, and I don't trust either one, and I don't trust our government. Let me make that very clear.
Rise Up put it very well. That's a fine line between coercion and advice for their client.
Okay.
Yeah, fine line. All right, folks, we're way over time now. I want to thank everyone for watching. Miss G, I want to thank you for co-hosting the show. And tune in tomorrow night. Is tomorrow night Friday or Thursday night? Oh, it's Thursday night, tomorrow night. Tune in tomorrow night. We have a special apology coming from Miss G
Never.
to me.
It's not gonna happen. But wait, real quick.
Everybody will want to see
Don't
that.
laugh. Don't smile yet, Davis. Not
Humble
yet.
pie.
Davis. Davis.
What?
Real quick.
I said good night. I got to tell everyone good night. We're way over time, Miss G. You
Okay.
know. Good night.